Welcome to Family Law War Room with Brad LaMorgese.
Hello, everyone, and welcome back to Family Law War Room with Brad LaMorgese. Brad is a board-certified family law attorney in Texas who specializes in high-stakes divorce, complex property division, jurisdiction disputes, and family law appeals. I'm Sean O'Connor, and today Brad and I are talking about prenuptial and postnuptial agreements and how these agreements actually hold up when they're challenged in real cases. Brad, it's good to see you.
Good to see you, Sean.
I'm interested in this, the whole prenup, postnup. I've heard lots of stuff in terms of where they're sort of coming back into style with younger folks who are getting married. But to start off, what objectives are high net worth individuals or business owners usually trying to accomplish through these, prenup, postnup agreements?
Well, at a high level, the agreements are about controlling risk and creating certainty in an otherwise uncertain situation, particularly for high net worth individuals and business owners. The goal isn't just asset protection, it's also predictability and less litigation, hopefully. They're trying to define in advance on how property would be characterized, how earnings will be treated, and what happens if a marriage ends. In many cases, there's a strong focus on preserving premarital wealth, family
Mm.
assets, closely held businesses, or long-staying investments. But it goes beyond that too, because these agreements often address how future growth is treated, how income generated during the marriage will be handled, and how to avoid valuation disputes later. So for business owners, there's also a continuity concern. They want to ensure that a divorce doesn't disrupt operations or trigger ownership issues or force a liquidation event. So when
Yeah.
these agreements are done correctly, they're not just legal documents, they're hopefully long-term financial tools.
Yeah, interesting. I could see that in terms of the business, especially in cases of a family business and where perhaps it's, there's different children involved and all of that. I've had many conversations about that sort of thing. Um, or I should say, what, from a litigation perspective, what distinctions matter most between prenups and postnups?
I think the biggest distinctions are coming down to timing, leverage, and then scrutiny. So premarital
Hmm.
agreements are signed before the marriage, which means both
Yep.
parties still have a clear choice. They can move forward with the marriage or not. And because of that, courts typically view prenups as less susceptible to claims of coercion or undue pressure, or in Texas, as we say, involuntariness or unconscionability. Postmarital agreements, on the other hand, are signed during the marriage, and that changes things, although they're still readily very enforceable. But there's already
Hmm.
an established relationship, sometimes financial dependence, sometimes a power imbalance. And so courts tend to examine postnups more closely because a fiduciary duty generally in Texas exists between spouses, but not between fiancés. So it's kind of interesting
Mm.
on the lenses, each one's judged a little differently.
Yeah, the premarital being obviously there's no legal relationship there. Uh, it's an interesting distinction. Where have you seen that marital agreements most commonly become, say, vulnerable to legal challenge years later?
Well, in Texas, they're really not very susceptible to challenge. We only have two statutory defenses, and you can typically eliminate even one of them during the drafting, the unconscionability defense. So it's going to come down to voluntariness. And to do that, we'll look at what sort of disclosure was made of the assets and values, if any. Was it was it
Hmm.
truthful? Was there anything intentionally concealed? And then was there time pressure? Although the courts generally say even agreements signed close to the marriage is really not necessarily a reason to overturn one. But I've had cases where one spouse got the other one intoxicated, and so that was thrown out. And then one of them, there was a switch of documents at the last minute. So it's in reality some pretty extreme circumstances that go towards voluntariness. And then particularly, I would say if an estate is quite large or if it's grown, there's more of an incentive to challenge an agreement like that, let's say.
Yeah, I see. Yeah. How significant, I mean, are financial disclosures in determining whether, a prenup or a postnup will ultimately hold up in court?
It's an important factor, but it's kind of interesting because literally you don't have to do any financial disclosure. I think the better the
Hmm.
job you can do at it, the more it's going to protect the agreement itself, the more honest someone is, because you can look at, well, what am I missing out on? What income or what would have this produced? I think also a more thorough disclosure can address those questions of fairness, even though the cases say the agreement doesn't have to be fair. In high net worth
Yeah.
cases, it's sometimes difficult because the party's own business is, are we really going to go out and get a full business valuation just for purposes of a marital agreement? And so frequently the businesses are just listed. Now we may say the estate is in excess of some big number if that's true, just to give everybody that perspective. So I think that the disclosure is helpful, but it's really not even necessarily required.
Interesting. Right. So, I mean, just in simple terms, I'm getting married. I have a business, Sean Incorporated. I make widgets. And my fiance, I'm like, hey, I've had this business handed down from my dad. I want to make sure I keep it in if something happens to our marriage, sign here. But I don't necessarily have to say it's a $10 million a year business.
Yeah, and you probably wouldn't in that case again, just because what if you're wrong? And then that goes to, well, were we being truthful or not? It's if we just disclose we have this business, it's owned before marriage, that's probably the better course.
So leaving it actually vague, not vague, but less detail. Hmm. When things, when a case is contested, how do the courts evaluate claims that an agreement was signed under pressure or without meaningful understanding of the terms? You mentioned someone who had, got somebody drunk prior to a signing, but are there other circumstances, situations you've seen?
Those are going to be super fact specific.
Mhm.
You do look at timing, how much, if there was a lot of time between the signing of the agreement and a wedding, that's a pretty tough because you didn't actually have to go to the altar, right? You
Yeah.
could not go to the altar and not have that agreement be effective. They'll look at, generally, did each party have the opportunity to have counsel or did they have counsel? They're going to look at the overall circumstances. Was there an opportunity to negotiate? Is this the draft everybody was looking at? Like I mentioned,
Mhm.
they'll look at, was one party, did they have the capacity or not? So it's, again, these pretty extreme factors to overturn one, but the courts are going to take those challenges seriously and look at them.
Well, and we touched on this a little bit. I'm curious how say closely held businesses or executive compensation structures, which can be pretty complicated, potential inheritances, or just generally family wealth. How does this complicate the drafting of these agreements? I mean, I'm sure it just more detail, right, and other things. I'm sure.
Definitely a lot more detail. There's layers of complexity that go beyond a basic asset division. And when
Hmm.
you're dealing with businesses, for instance, you're not dealing with a static asset. Frequently, it'll grow, it'll evolve, it will generate income. And so the agreement will address all those angles. In the real estate business, for instance, that you'll see frequently each transaction will have a different entity. So we would treat all of those uh, after acquired businesses also as separate property potentially. Executive compensation can be quite lucrative. And so we'll go over all those things. Family wealth and inheritances, those are other layers. Dealing with income from that family wealth and trusts are very important to address. And we're even seeing some interesting new emerging issues like clauses we'll work on intellectual property.
Mm.
cryptocurrency,
Yeah.
these sort of things. So it's become even more interesting and definitely a growing area.
Yeah, the digital realm, and then, yeah, the idea that who owns the script when it gets written? Yeah, or, whatever, different intellectual property consideration.
And who owns derivative works? Like Tom Clancy's divorce, he stopped writing about his original character because that character was split in the divorce. So then there were new characters.
What, when these disputes do reach litigation, what kinds of factual or procedural details tend to shape the outcome most prominently?
I think, like we were talking about, if there was a sort of a gross intentional misrepresentation, those are big. You see courts, they're going to examine the evolution of the asset too. And while that's not always relevant, I think in all of our minds that the size of the wealth that somebody might be missing out on is it's an unspoken factor, I would say. And then, but really, when you're looking at voluntariness or unconscionability, you're looking at what were the representations that were made and what happened really with regard to the execution and then sort of the aftermath of it. So they're really looking at the facts surrounding the signing of these things.
You know, is there any, maybe you could share an example, or, or marital agreement dispute that kind of illustrates how sophisticated these cases can become once they're challenged?
Well, there was a case within the last few years at the Texas Supreme Court, not my case. And it
Hmm.
was addressing, we were always wondering, is a forfeiture clause valid? So in that case, the wife was going to get, I think, millions of dollars so long as she didn't challenge the agreement. And the trial court found she challenged the agreement and forfeited these millions of dollars. And it went all the way to the Texas Supreme Court, and they said, yeah, that can be valid. That can be something that can be put into a marital agreement that's important to people to, again, to not be dealing with the litigation of it. So that was a major
Mm.
complication in that case.
Yeah. Oh, that's interesting. And so literally, it was like, hey, here's the agreement, and look, if we split up, you're going to get, let's just say, 10 mil. But if you question that, you'll get nothing. And the motivation there is that, look, I don't wanna get dragged into a long litigation and time, money, all that stuff, and so
Yeah, and the court, I call it a poison pill clause, but the court called it a contingent benefit. So you can make the benefits conferred by a marital agreement contingent on not challenging it.
that's interesting. And then, yeah, now I'm into, like, okay, conscionability or, what's the term?
Involuntariness.
That's it. Yeah, yeah. Yeah, it sounds like it's no. It's like, wait, is that blackmail? No. Uh, you know, looking at the agreements, that survive scrutiny versus the ones that unravel, what patterns tend to separate the two? What's the difference between one that stands up and one that gets tossed out?
I think it starts with hopefully precision drafting. You're dealing with as much of a disclosure that can be truthful and honest, like we were talking about. You don't want to over represent something that's not true. Or in particular, if you're trying to protect wealth, you definitely don't want to under represent willfully, at least. You typically would see both sides represented by counsel. It's not required, but it's going to make it more difficult to challenge an agreement. Not impossible. I think the ones that don't survive, you're seeing a lot of gaps. You're seeing even potentially very complex drafting. When I draft these, I try to keep them very simple so that everyone will understand years later what we all meant, rather than the parties frequently at the beginning will think, well, let's do this complex structure, or let's give X percent of the valuation later. And I frequently try to dissuade people that put in a specific dollar figure, put in something that's very specific about what's going to happen, so that you don't have that future litigation.
Yeah, interesting. Also, that the idea of um, representation, right? So assuming, we're in a high net worth context here, and so there's a lot of assets and some complexity potentially as some of the factors we were talking about earlier. And uh, my spouse is the one with all of the assets, let's say, as and agreements get drawn up, and I may well be, of course, we're on great ground. I trust her implicitly, right? Et cetera, et cetera. But you might, in that context, still recommend that, hey, it'll be better if you get an attorney just because of the scenario you're talking about. If in 20, there's no way to foresee, but 20 years from now, it'll just be like, okay, like you said, it'll be on the record, so to speak, that all eyes were on this and it was scrutinized and uh, given a green light.
Yeah, I think so. I think it's always best for both sides to be represented. I think it's a good feeling, and that doesn't mean that anybody has to accept what the other side wants, but you're getting good legal advice, and I think sets up the marriage better too.
Well, Brad, we're up against time, which always seems to happen. But as always, great to see you. Great to talk to you. Thanks for sharing your knowledge and point of view on all of this.
Thank you, Sean.
That's it for today's episode of Family Law War Room with Brad LaMorgese. To learn more about Brad and his work in complex family law matters, visit the website lamorgesefamilylaw.com. Thanks for listening. And don't forget to maybe leave a thumbs up, share a review, maybe share a link with someone in your world who has a complex marital agreement that's pending. That can always be helpful. I'm Sean O'Connor. Have a great day, and thanks for listening.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.